right. Good morning, Mr. Goheen Rango.
Good morning, Mr. Wheeler. Hey,
And Your
morning,
Honor,
Miss Carney.
uh, I'm here on behalf of my client, Mr. Goheen Ringo. I have filed a motion, which I understand Your Honor has reviewed. I still maintain that there is an irreconcilable breakdown in the attorney-client relationship. I do want to provide some information to the court. Spoken with Mr. Goheen Ringo this morning. He believes that our breakdown in communication and our issues as far as it relates to our attorney-client relationship are capable of being repaired. I am being truthful to the court that I disagree with that assessment. However, I want to be fair to Mr. Goheen and let the court know that. He's asking that we set this matter over to next week for me to go and see him in custody in the jail. I would have seen him this week, and I don't want to get into there was a miscommunication between he and I. I thought he supported this motion based off of certain factors that I'm not going to get into. He no longer does. I'm welcome. I think I'm back next week, but even if I'm not, I'm welcome to come back next week if it was set over for he and I to talk in person in the jail. I do not believe, I don't have a good faith basis that any discussion that he and I have will change my position as to the.
Buckle up, guys. Today we're going inside a courtroom moment where a simple hearing quickly turns into a breakdown of trust between attorney and client. What starts as routine proceedings instantly shifts when the defense attorney declares an irreconcilable conflict and moves to withdraw from the case. The tension rises as the judge is pulled into a situation where both communication and legal trust are already collapsing before any real arguments even begin.
The breakdown, particularly relating to one issue that I'm not capable of ethically discussing with Your Honor, and a second issue which was discussed in open court relating to my or to the client's belief that I've waived attorney-client privilege. I believe that raises an unwaivable conflict, which I've already been frank with the client about. That being said, he's also asked me potentially about moving forward pro se. I have strongly advised him against that. I don't believe it's a good idea for any client to represent themselves, but he also has a significant experience with litigation. He's been in jury trials, I think, and as well has had lengthy, time to basically research these matters in the law library. We are here today. I'm still supporting a motion to withdraw, and I just wanted to provide Mr. Goheen Ringo's perspective to the court. So I don't know if he wants to speak or not.
So I think my thought is, Mr. Campbell, if you are willing to meet with Mr. Goheen Rango, sounds like sometime before court next Thursday, I don't think anything will be lost. If indeed after that your position is the same, I think the court would at that point allow your withdrawal. But I want to give every opportunity for this to hopefully work. So I'm going to be setting this matter over 1 week. That takes us out to the 8th of May.
And Your Honor, I haven't reviewed the matter for speedy trial issues this morning, so I'm not sure. I think the waiver was to the 14th of April.
Mr. Goheen Rango is not being held on any of our cases. He's in a 90-day speedy trial with commencement dates, I want to say on the 24th of April. So we're not very far into speedy trial.
And I for some reason, this file, I have other files I think back that may have it, but I believe the commencement date may be the 14th of April. But
let me take a quick look here, seeing as we have the files right here. So the speedy trial waiver that I can see all 3 cause numbers on has April 17th,
right,
2025. So even if we set out to May 8th on a 90-day speedy trial calendar, we're not even 30 days into speedy trial. We needed to go ahead and set matters for trial.
All right, guys, what unfolds here is a deeper exposure of why this attorney-client relationship has completely fallen apart. The lawyer explains to the court that there are ethical and communication barriers that cannot be repaired, even after speaking with the client in custody. The judge tries to slow things down, suggesting a temporary pause so both sides can meet again before a final decision is made. But underneath that, the case is already tilting towards separation, with speedy trial concerns quietly entering the conversation as pressure builds inside the courtroom.
Thank you, Your Honor. I just wanted to be clear on that point.
All right.
Your Honor.
Yes, Mr. Goheen Rango?
Hey, just had a quick question. I've been hearing that term a lot today, speedy trial. And I took 3 years of AP government politics in high school. I'm sort of roughly familiar with some constitutionality about that, but I'm just curious today if you could give me something to think on for the next week till I talk with Brandon. As far as for the position of a defendant, what's the purpose of a speedy trial? And why does it have to be speedy?
I think what was happening, Mr. Goheen Rango, historically was people were languishing in jail with no definitive time frame. And certainly there's been times where speedy trial has been suspended. Most recently, I think, when there was an emergency order during COVID, speedy trial was suspended at that time just because we couldn't safely impanel juries. So generally, a person who is in custody has the right to be brought to trial within 60 days. Does not mean that's always the best strategic choice, depending on the complexity of the case. And a person who's out of custody generally has to be brought to trial within 90 days. Certainly, that is a privilege or a right, that a defendant can choose to waive. And a judge like myself, whether it be over Zoom or in person, is going to make a colloquy with that person, making sure that they understand their right to speedy trial, making sure that they understand that from the new commencement date, so in your case, when we last did the speedy trial waiver, that you understood the 90-day time frame for the particular cases would run from April 17th. And ultimately, it's the defendant's choice whether that speedy trial time frame be waived. So that would be my recitation on that.
Now things shift into a more controlled but highly important legal explanation as the judge breaks down what speedy trial actually means. The defendant, curious and slightly overwhelmed, questions the system and how long someone can legally be held before trial. The court explains strict timelines, custody rules, and how waivers can extend those limits. What makes this moment stand out is the contrast between legal structure and human confusion, as the defendant tries to understand rights while still sitting inside a case moving against him.
Okay.
Thank you, sir.
Yeah, thank you. Can you hear me? Oh, sorry, I got muted there for a second. Since my case here in Superior Court,
Please, this
Yeah.
is your attorney currently, Brandon Campbell. I don't recommend you speak in open court, and if you have questions about speedy trial, we can discuss them when I come into the court or come into the jail between this week and next.
Thank you, Brandon. I'm still just talking with the judge. Thank you.
Just to
So
be clear, it's against my advice to talk to the judge because he's not
I understand that.
to give you advice.
All right, I'm going to try to get back on my train of thought here before my turn is over. I have a court matter that I'm currently facing right now here in Superior Court. I don't need to go into detail about it. It is a false allegation, and I've been sitting in jail, languishing for 7 months. Meanwhile, my attorney in that case, which is not Brandon Campbell, Brandon has been awesome. He comes to see me often. He's seen me more times in the short amount of time that he's been my attorney than altogether, twice the amount of time than my other attorney who refuses to come and see. It's been 5.5 months since she's been here to see me. And so I'm wondering how I could still be languishing. Yes, it's a different case about a Superior Court matter. But without being able to work on my case here, I know you've released me, which is very gracious, and I always thank you for that on the older cases. But since these cases preceded my involvement in this newer case 7 months ago, when I was attacked, and then the police they arrested the wrong person and never got my side of the story.
I really recommend you don't speak about this On the record.
Okay.
And I think,
Don't
Mr.
go
Goheen
any-
Rango, where I'm going to go with this is, it's this
Yeah.
thing that I tell everyone in the courtroom today, and if you were present in the courtroom, one of the things that a judicial officer cannot do is provide legal advice. And I think you're asking me to provide legal advice or to make a ruling on a case that I don't have any information on. Certainly, those are issues very clearly that need to be brought up with your assigned attorney. I can't make a ruling or provide legal advice on a case that is not before the court.
I understand that.
I would additionally also say, like Mr. Campbell is, you are on a record and you are making statements. And if that attorney were here, I'm sure they would ask you not to make any statements that might be against interest. So that concludes your hearing. Thank you, Mr. Goheen Rango. I'll see you next week, sir.
Yeah.
All right, Mr. Campbell, I'm assuming ready on Mr. Goheen Rango.
That's correct, Your Honor.
Morning, Mr. Goheen Rango.
Mr. Judge Wheeler
Go ahead,
and
Mr. Campbell.
everybody.
I don't, I'm sure Your Honor may recall some of the discussion in last hearings regards to the defense's motion for counsel's request to withdraw. I've had opportunity to speak with Mr. Goheen Rango in custody since that last hearing last week. I still have a good faith basis to indicate there is not a pathway moving forward to repair our relationship, in my opinion. The client, I believe, over my objection, wants to make an oral record of his own. So I'll defer to him if he's going to do that, but did provide him an opportunity for me to provide to the court his presentation to protect his right to remain silent. But ultimately, I believe that there is the perception of an unwaivable conflict based off of the client's statement that I waived his attorney-client privilege, damaging his case. And even if I disagree with that assessment, there are certain waivable conflicts that I am not capable of overcoming these conflicts with the client. In my opinion, I don't believe the client is able of overcoming my concerns. And so those are the grounds upon which I'm seeking to withdraw. I have done a little bit of research on the case law surrounding these types of circumstances where a client is objecting potentially to counsel's withdrawal. I could, if Your Honor has concerns about that, I can put those into writing or recall the matter. But ultimately, I believe that at this point, my counsel of Mr. Goheen Rango should be ordered withdrawn, and counsel should be substituted in for his trial in these matters.
Let me ask you, I am going to allow Mr. Campbell to withdraw. Mr. Goheen Rango, I was present in court when you elicited that attorney-client privilege had been violated, and that you felt prejudiced by that. I don't think we can walk that back. That was on the record and part of the court proceedings several weeks ago. So I'm going to grant Mr. Campbell's motion to withdraw.
This part takes a sharper emotional turn as the defendant begins speaking about his situation in custody, describing long delays, frustration, and feeling unheard across multiple cases. The judge steps in repeatedly, warning him not to discuss unrelated matters and reminding him the court cannot give legal advice. At the same time, the attorney-client breakdown becomes undeniable on record, with the judge ultimately agreeing the relationship has collapsed beyond repair. The decision to allow the attorney to withdraw marks a major turning point in the entire proceeding.
My question, Mr. Goheen Rango, because I know it had been floated to the court two different ways. One way was that you were choosing to represent yourself now. The second would be if you are asking the court to assign you a new attorney. So my first question is, are you planning to represent yourself at this stage, or are you asking the court to appoint you another attorney?
That's a really good question. That kind of cuts me off from what my train of thought was going. I had a question that maybe should go before that question, but I was just wondering, is that all that's necessary for a judge to remove an attorney? Is that just whether it's true or not, someone who's been accused of a crime can just simply mention that he believes that an attorney has violated his attorney-client privilege, and that's all it takes to have that attorney removed.
No, because even prior to that time, you were
Yeah.
expressing to the court that very day that you believed that Mr. Campbell was not working in your best interest.
Okay.
It seems that apparently that morning there had been some conflict between you and Mr. Campbell of some nature prior to the court proceeding. Again, I'm not privy to that. It sounded like both
Yeah.
people.
There
had a
was
meeting.
no conflict. There was no
Again,
conflict.
But again, after that proceeding, after Mr. Campbell's statements on the record, your statements on the record were that your attorney-client privilege had been violated, which is
Right.
not revocable. I can't ask why it was violated because again, that's attorney-client privilege. So
Okay.
you invoked that in attorney and the defendant, but I think
Okay.
when we add on top of that, also statements that attorney-client privilege had been violated and there was an intractable relationship at that stage, I think that seals the deal. So
Okay. I didn't know. I definitely wouldn't have said those things had I known that this would be the consequence. My concern with it, if I can recollect where my train of thought was that day, was I thought he had mentioned a few details that I didn't want mentioned on the court. I think if I went back,
And
I
again, we're
believe he did.
not going to go into that today because if indeed those details were subject to attorney-client privilege, we're not going to restate them and point out to them which ones you thought they were. Because again, you would be you'd be invoking things that you said were privileged to the court on the record in open court.
Okay.
So again, where we are going with this is a very simple question. Are you asking to represent yourself moving forward? Or are you asking the court to assign you another attorney?
I think I would like to be assigned an attorney. Now hold on. Actually, if I represent myself, will I have facilities to be able to do that while I'm in custody here, or can I be sent a packet on instruction how to you know how to do this? Because I don't know. Might be interested in that.
The court cannot provide you materials in good conscience that are not already available at the Clark County Jail and what is provided there. That would be the court inserting itself into your defense, and the court is an impartial fact finder. The court's responsibility is not to assist people in self-representation. So
Okay.
the issue that this court has is there's a conflict with every existing attorney that this court has with you, or a conflict based on we don't have anyone left. So the court is going to have to explore in the next week whether we can find an attorney in Clark County that will accept representation. I'm not going to go any further than that, but that's the status of the court. So I think we're going to have to set this matter over 1 week, and the court will have to reach out and determine if we can find counsel. Yes, Mr. Goheen.
Is there there's a few attorneys that my mom's been supporting me throughout all this. She's been in contact with. Would it be possible to have them apply personally, or is it just only on the court's behalf to go seek one out? In other words, can one volunteer, one that we've been talking with, or?
It would have to be a licensed attorney,
Of course, yeah.
in the state of Washington that has some background in criminal defense. I'm certainly not to have a tax attorney in here trying to navigate a jury trial.
Yeah.
But if there is an attorney that you are aware of that is wanting to accept your defense or availability in court, that's where we'll go. But
okay. So, and then they just have to show up, or on on the Zoom or in person on the next setting?
They would have to contact the court prior to the next setting. The court would have
Oh.
to vet whomever this is, vet
Yeah.
their availability and so forth. So
Okay.
it can't be a surprise guest behind door number 3. It has to be someone who has contacted the court. We're going to see you again next Thursday in 7 days. And we'll see what we can do. Okay.
And Your Honor,
All right. Thank you, Your Honor.
I just wanted to check our speedy. I don't have the commencement right in front of me.
I want to say is April 17th.
Okay.
So we are going to be 30 days elapsed.
Right,
Mr.
okay.
Goheen Rango is not being held on these matters. Let me look though. I remember that the waiver, let's see.
Have it entered.
April 17th, entered February 20th.
Thank
So
you.
we are 32 days elapsed next Thursday, the 15th. Ms. Carmi, do you have an objection of this matter coming back next week? I know that you are not personally going to be present for, I suppose, the assignment of counsel. My recollection, if we have withdrawal, is that speedy trial will recommence with the assigning of a new attorney.
Yeah, I have no objection to this being heard next week.
Okay. All right, Mr. Goheen Rango, we are going to see you next week, sir, and we will work on getting you counsel. Thank you.
Thank you, Your Honor.
Yep.
Thank you, Ms. Carmi.
Thank you.
Thank you, Brandon, if you're still there.
All right, guys, this is where everything converges into a final courtroom resolution with major consequences. The judge officially grants the attorney's withdrawal, but immediately raises a critical question: whether the defendant will represent himself or receive a new lawyer. The court realizes there is now a broader conflict affecting all available counsel and decides to search for a new attorney within the county. A 1-week delay is set, keeping speedy trial timelines in motion while leaving the case in uncertainty. And with that, the hearing ends on a suspenseful note, highlighting how quickly legal control can shift inside a courtroom. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.